That being said, one of the misnomers about trusts, people think they somehow offer some sort of magical protection against creditors, or
Right.
they offer some magical protection against the state. They have magical tax powers. And none of that is true, unfortunately. Trusts are just as vulnerable to creditors and state consideration and problems just as wills are. And that's where I find that there's the most misinformation.
Welcome back. I'm excited to be joined today by Danielle Palm, an attorney who's been practicing for over 20 years. Throughout her career, she also supported her husband in the Coast Guard, traveling across the country for over a dozen years. Found the best beautiful place on earth to settle, which is Liberty Lake, showcased in the image behind her, where she's raised her two young children, one of which just started college. And I'm excited to talk to her about the most common question that she gets from her clients. So, Danielle, thank you for joining us today.
Well, thank you for having me, Taylor. I really appreciate it.
I'm just going to dive right into the meat of it, which is the number one question I hear is, do I need a will? Do I need a
Mhm.
trust? Can you break that down for our audience today so they can better understand will versus trust and what is right for them?
Absolutely. This is probably the most common question I get. Do I need a trust? And you're right. There's a lot of buzz around the trust. The conclusion I've come to, you're going to love this one. It's a typical lawyer answer, and you're going to hear it throughout the day, is it depends. I know there are attorneys who are diehard will attorneys, and I know there are attorneys who are diehard trust attorneys. I am somewhere in between those two. I feel that sometimes it depends on the client. It depends on who the client is, what the client's goals are, how the client holds their assets. Family dynamics can play into this, where they own property, what states are involved here. So there's a lot of questions that go into finding that answer. And one thing I can say is that historically, a will was always the device we used to do our planning, our death planning of where we want our assets to go and who we want to be in charge of doing that. But as we all know, things have become more complicated over time. Over time, a lot of states passed laws making the whole will process, the probate process, we'll talk about that a little bit more later, making that process very complicated, difficult, people wanting to avoid it. So
Sure.
we have the invent of the living trust, which is an alternative vehicle for passing assets. But what it ultimately does, if executed properly, is it avoids probate.
Right.
And this sounds very attractive. I will say this, however, whether or not this can also come down to state law. Every state is very different on how they treat wills and how they treat the probate process.
Right.
I hate to do this, but I'm going to pick on California because they notoriously have some of the worst probate laws in the country.
Yep.
It's a very expensive process, it's a very time consuming process, and it just invites a lot of problems. And so, if you talk to somebody from California, you're going to find that everybody has a revocable living trust. And
Sure.
that's much based on state law. I will say Washington, we're considered a will-friendly state. We're a pretty probate-friendly state. Our process is pretty straightforward. It doesn't seem to be as expensive as I see in other states. There's no statutory payment that the attorney is entitled to. Let me correct that. In California, the attorney can be entitled to a percentage of the estate based on state law. That is not the state law in Washington. But I will say overall, the will versus trust thing can really come back to the client's goals. I would say that most of my clients don't need a trust because often they have very simple estate planning. And sometimes we can even do it without a trust and do direct beneficiaries and even do it without a will and avoid probate.
Right.
We have lots of great tools, is my point here. And to me, there's no one size fits all. So it's imperative that you go and talk to an attorney, explain your unique situation and what your goals are, and have that dialogue with the attorney and learn about what vehicle is going to be best for your situation. The attorney will, give you advice on that and figure that out. Now, probably the most frequent time I'm doing trusts are clients who own out of state property. We don't want to have legal actions in 2 different states or 3 different states or however many states when they pass away. And we want to get it all consolidated into one cohesive pot and unit. Then a revocable living trust is a great way to do that. So like I said, it just really depends on the client situation.
Really empathize with that. I feel like on my side of the fence, like one of the most common questions I hear is, how much do I need to retire? And there's a lot of
Mhm.
buzz around the $1 million figure because it's a nice round number and say, if I have $1 million, I should be fine. And of course, my response is the same as yours. It depends. How long are you going to live? What are your other income sources? Do you have a spouse? Do you have a mortgage? And how much do you need to
How much
spend?
money are you spending every month? That's
Exactly.
yeah, I hear you on that. It just depends. So we talk through that, we work through that. I like to offer my clients all their options. Say, if you do a will, this is what it would look like. If you do a trust, and I literally will draw it out on a piece of paper
Sure.
of what the different pros and cons of each, the disadvantages and the advantages. And I let them decide because trusts are a little bit of an investment up front. You're going to pay more for a trust than you will for a simple will.
Hmm.
You got to put all your assets into the trust. So there's again the upfront work and the upfront cost. But for some clients, that's what they want to do. I have
Right.
other clients who are like, I am not interested in doing all that work. My kids can deal with it when I'm gone. I'm leaving them a lot of money, so they're going to be just fine figuring it out on their own. So again, it's really client centered and on what their goals are and trying to get them where they want to be. And I also tell people, and it's okay for that to change over time
Right.
because your situation may change over time. You may buy property in another state. You might sell property in another state. You might be looking at unique family situation that's come up,
I was about to say,
blended
yeah,
family, marriage, divorce. Things happen, life happens. So I tell
definitely.
them we want to come up with the best plan possible, but you're going to have to be open to it shifting over time because it's
No,
inevitable.
I think that's perfect. And one thing, if I can highlight, correct me if I'm wrong, but what I love about your process, Danielle, is you start with education, right? It's not a
Yeah,
matter of someone comes into your room and they walk out with a bill and they say, I don't know what
that's
just
right.
happened. I love that
That's
you try and lower that barrier to entry to say, let's understand your situation. You may not walk out the door with all the answers and much less any completed
right.
documents today, but you're going to have a
Absolutely.
really confident trajectory towards, do I need a will? Do I need a trust? And if so, what do those look like, cost wise, benefit wise? So I think that's something else that not all attorneys
Yeah.
offer, but I do find important for the audience to know you do offer that free initial education. And throughout your process, you're very education oriented. So clients feel confident about the decisions they're making every step of the way.
Absolutely. You've nailed it on the head with that. I think the education is the most piece because I'm not trying to convince them. It's my job to educate them on what is available to them and then let the client decide what is most important to them. I think that attorneys can be intimidating and people are worried that they're going to walk in and be sold something immediately. I don't want it to feel like a sales pitch. It's not a sales pitch. I can provide a service and a gift of documents and information, but it needs to be centered around the client's needs at the end of the day.
Speaking of misplaced fears, you brought up another P word earlier today around probate. So you did say that although someone may not be needing a trust, if they have a will, they will be subject to probate. Can you highlight why that may not be as concerning, as, at least in the state of Washington, as many people think?
Absolutely. Yeah. I will say, again, that's the way we've historically done it. And Washington's really held on to being a will friendly state. And by will friendly, I would say it's still the main vehicle that most estate planning attorneys are proposing being used under most circumstances because we're not afraid of the probate process. Probate is, and I just want to explain for a minute what probate is because
Please.
people often don't really understand. Whether you have a will or whether you don't have anything, in order for people to get legal authority over your assets after you die, we have to go through what's called the probate process. And this is where we have to go to court. And if you have a will, we get your will admitted to court. But we're basically telling the court the story and saying, this person has died. Here are their heirs. Please put this person in charge of their estate. If you have a will, you've picked that person. If you don't have a will, then the state has decided who that person is for you through their statutory list.
Right.
Spouse first. You don't have a spouse, then to kids. If you don't have kids, then to grandkids down the line. If you don't have any of those, it starts going up to parents. And if you don't have parents, it starts going to siblings. You can see how it goes.
Sure.
So there's a statutory line. Either you pick them in your will or the state will decide for you. But either way, in order so somebody could have legal authority over your assets after you die, they had to get appointed as the representative of your estate by the court. The court has to okay it. And that starts what's called the probate process. In Washington, I tell my clients when I do a really basic uncontested probate, it usually takes 5 to 6 months total. During that time, most of that time is waiting for a creditor's claim period to expire. But during that time, the representative can be liquidating assets, doing whatever business they need to do. So things are still happening. It's just we can't do final disbursements until the end of that 4-month creditor's claim period. And then we can do final disbursements. So I tell people 5 to 6 months, usually logistically. It's not hard to open probate in Washington. It's a very straightforward process. Some attorneys will charge an hourly fee, some will charge a flat fee. I'm finding most probates tend to cost in the somewhere around the $4,000 range is about average nowadays, I think. But it depends on how complicated the estate is.
Sure.
It could be more if it's more complicated. Some people want to do probate. They want that accountability. They want that it's an open book of what's happening. Some people feel like it's actually makes things more straightforward and clear, and there's not the secrecy and privacy that can happen behind a trust. Other people don't want to have anything to do with that process. They think it's inviting trouble. I've told people my position on that is I don't care if you have a trust. I don't care if you have a will. I don't care if you have nothing. If people are determined to fight over your estate, and whether or not they have a valid claim is a different question, and most of the time they don't. But
Sure.
those aren't fears that I have, because most of the time it goes really straight. If you have a good will and you get a good attorney, it goes right through probate, and like I said, in 5 to 6 months you're done with the whole process. It's not super expensive. Like I said, in Washington we don't have that statutory percentage, so attorneys aren't subject to that, and it's just not a big deal.
One thing that sparked my curiosity, as you said, about anybody who wants to mess with your estate or go after parts of your estate can do it either way. That doesn't strike me as a very common instance. Is that a threat that would come from within the family of other people who think they should get claims on an inheritance? Or are we talking about creditors or just
All of them, all of
all?
the above. Anybody who thinks they have a legal claim against the estate,
Okay.
they can come after assets. And if you need long-term care in Washington, they can also consider them for that as assets that you need to spend down. And that's probably that's a different conversation for another day. But
It is.
um,
Yes. Okay.
yeah, but here's the other thing. Even if you go the will route, we also have some other great ways of passing assets that don't involve either one. This is
Definitely.
one I know that you work with, which are direct payable on death beneficiaries.
Correct.
I love that when it fits, right? It doesn't fit every client, because
Mhm.
not every client wants money to go directly to beneficiaries. Sometimes we
Right.
need to protect it a little bit more.
Yep.
But if the shoe fits, direct beneficiary designations, that's my favorite way to pass assets.
Yep. And if I
So,
could zoom out a bit, since you brought that up, Danielle. So as I look at the client's entire net worth and a financial planning perspective, they have usually their bank accounts, their home,
mm,
maybe some toys. They've got investments, and that for most people, that's a really simple way to sum up their net worth. But as far as
mhm.
their investments go, you're right. With their retirement accounts, 401k, IRA, Roth IRA, as long as they have designated beneficiaries, those fall outside the purview of a
Yeah,
will and probate
it's all
process.
outside the wall. Yep, for the audience's sake, is anytime you put a payable on death beneficiary on an asset, you are creating a contract with that company, whether it's your financial advisor or it's your bank. You can even put payable on death on your regular checking and savings account, but
Right.
you're creating a contract with that institution. And that contract holds, and it doesn't matter what we put in a will or a
Exactly.
trust or any other device. That is a contract that's going to be honored.
Took the words out
Yeah.
of my mouth. I always emphasize we have to check the beneficiaries. Even if you've worked
Mhm.
with us for 20 years and we met every
Yep.
year, we check the beneficiaries, because if you pass away
Yep.
tomorrow and the
Yep.
beneficiaries in your will disagree with the beneficiaries on your IRA, the IRA wins.
And
So,
so like you, when I have clients come in and we're talking about beneficiary designations, they say, "Oh, I think I already have that taken care of." I always say, "Now is a good time to check. Call your financial advisor, check with your life insurance policy holder, whoever it is, go to your bank, but double check and make sure that's clean and tidy."
exactly.
Yeah.
So as far as the
Yeah.
net worth goes, as I look down at clients' assets and what they own, the home, yes, gets subject to probate if they just use a will. Bank accounts, I think we'll get to that in a minute. And then the investments, those can be set up to, as you mentioned, fall outside of the purview of this probate process. So for
Yeah.
most of my clients, there are always ones that are more complicated, but for most of my clients, from an asset transfer perspective, probate only really applies to their home.
We do have a lovely little tool in Washington that I use for the appropriate clients. It's called the
Right.
transfer and death deed. And it's a legal way of adding a beneficiary to real property in Washington that works.
Fantastic.
So I can honestly often get clients, if they have a really straightforward situation and they fit into the right criteria, I can often get it to where they have everything passing outside of their will and going to direct beneficiaries. So the will essentially becomes a safety net, is what I call it for them. We still want to have a will for any unanticipated assets that we may end up with, because we don't have a crystal ball and we don't know exactly what we're going to die with. I'll joke with clients about, if you die with the winning lottery ticket in your hand, we got to know where your winnings are going and who's going to be in
Exactly.
charge of doing that. So we still
Exactly.
have to have a will, but we may not even need to use it.
Yep.
So that's how I feel about that.
Completely
So
agree. So to
yeah,
that point, we talked about the investments. Another major asset clients have is their cash, their savings, their bank
yep,
accounts, right?
yep.
Many times clients think, oh, I've added my children to the bank accounts. I should be okay. That's another
Happens.
misconception I think you wanted to speak
Yeah.
to.
So that's one of my other frequently asked questions
Okay.
is, yeah, I've added so and so to my bank account. That should be good. And the answer is, again, it depends, but most often the answer is probably not, unless it's a spouse. It depends on the amount in the account, and it depends on the other family situation. But what a lot of people don't understand is that when they go to the bank and they add somebody to their account, what they're often doing is they're adding them as that person as a joint owner. So we've got
Right.
joint ownership, and it's also with what's called right of survivorship, which means that the funds in there belong to those two people. And if one of them dies, all the funds go to the other person. And that sounds great. What they're often doing is they're adding them as a joint owner, which creates joint ownership. And it's also with right of survivorship, which means you both own those assets. And if one of you dies, the other one automatically owns those assets. And
Yes.
this is fine if you fully intend on all those assets going to that one person. The problem that I have come across, for example, I recently had a client, she had $200,000 in her checking account and had added her son to the account as a joint owner so that he
Mm,
could pay her bills or
mm,
continue to pay her bills if she died. What she didn't understand was, however, she has three children and she fully intends on that money going to all three children, what's left over when she passes. And I had to explain to her that from a legal perspective, when she dies, that money belongs to her one son, who's the joint owner on that account. And the problem with that is there could create some issues there. And that's a large amount of money. If it was a
yeah.
small amount of money, I'm not as worried about it. And this is where I said it depends. It does depend. But she has a lot of money in there, and that's his money. So, number one, if he's getting sued, the creditors can come after that money if it's his money,
Right.
and they don't care who else she promised it to. Number two, another issue I've seen is where people do this is, if he takes that 200,000, it's his 200,000, and then he tries to write checks to his siblings for 1/3. It's
Yeah.
actually now considered a gift,
Yeah.
and he
Over
is exceeding.
18,000. Yeah.
So now there's gonna have to be gift taxes paid on that. She really still wanted to have an account with money in it that he could pay bills, and when she died, pay her funeral expenses. So I said, okay, tell you what, why don't you take like 180,000 out of that account and go talk to your financial person, go to the bank and have it go earn some interest or do something, like it's just hanging out in your checking account doing nothing anyway.
Yep.
Go put it in and go list all three of your kids as the payable on death beneficiaries on that account.
Yep.
Meanwhile, leave like 20,000, we'll call it your operating account. Leave that in, leave him on it. I'm not as much worried about 20,000 as I am 200,000, because again, now if he does decide to divide it up, we're way under gift tax limits. And so there are other solutions, but these are, again, things, don't just assume that adding a kid to the account is the best solution. Here's the other main problem I see with that is that that gives your kid access to your bank, but it does not give them access to anything else. It doesn't give them, if there's money with your financial advisor, if you have an insurance company, if you need to talk to the utility company,
Yeah.
you being on their bank account does nothing for you. So that's why it's imperative to have talk to an attorney, find out what you need to have in place in addition to having the child on the account, if that's what ends up being the best solution. for you in
I
that
think you
way.
sum it up very well. From what I've seen and my clients that I sent your way, if people are looking for an accessible attorney to work with, you're looking at her. So
Yeah.
really
Yeah.
appreciate your insights and feedback. And for those that are interested in continuing the conversation with you, I'll put your contact information in the description of this video below so they can reach out to you. Is the best way via phone call or an email? What's the best way for them
All of
to?
it. You can call and make an appointment with me. I'm happy to work with people wherever they're at and the most comfortable. So,
Awesome. Fantastic.
yeah.
Danielle, I
Yeah.
really appreciate your time, your expertise, your insights.
Absolutely.
I know I learned some things today, so I really appreciate it. Thank you.
And thank you for having me. I love working with partners on this stuff and the education piece. I think we both agree on that, how important that piece is. So thank you for having me and giving me an opportunity to share this information.
Of course. Pleasure. Thanks, Danielle.
Thanks, you too.
Take care.